Okay. So now formally, good morning to everybody. It's a pleasure to be here for this second day of hearing in case ICSID ARB /19/34. I would like to welcome again both parties, their counsel, and also all those who are attending this session via Zoom. We're mostly welcome, and I'm sure that we'll have the same quality of audio and video for you as we had yesterday. Before we start, I'll ask claimants first if you have any housekeeping matter that would be willing to address to the tribunal.
We don't at this time, Mr. President.
Okay, thank you.
We don't have anything else.
We don't either. Okay. And the tribunal has no matters to address to you either. So let's get started. And then we have 60 minutes for respondents' closing arguments. The floor is yours.
Dear Mr. Chairman and arbitrators Vici and Cohen, perhaps the most distinguishing feature in claimant's case as presented yesterday is the allegation that somehow, after 2 rounds of written submissions and a 2-day hearing in Washington, D.C., this is not the moment for the parties to fully argue on proof and for the tribunal to definitively decide on Colombia's preliminary objections. The opposite is true. You have all the elements necessary to render a final decision. To say it clearly, by express mandate of the treaty and of the tribunal, this is the right moment. According to Article 1024, and I quote, "A tribunal shall address and decide as a preliminary question any objection by the respondent that, as a matter of law, a claim submitted is not a claim for which an award in favor of the claimant may be made under Article 1026. Moreover, as provided in sections 14.7 and 14.8 of Procedural Order Number 1, this is the moment to decide on respondents' objections to the admissibility and jurisdiction, including our objection that the services contract does not amount to a protected investment because there is no investment risk under the treaty and the ICSID conventions." Yesterday, claimants made an interpretation of domestic law that I take issue with. First, while Article 1028 of the TPA defines national authority as an authority at the central level of government, claimants denied the relevance of our domestic law, which clearly and expressly provides that Refinería de Cartagena, Reficar, is a decentralized entity, not an entity of the central government, and therefore not a national authority under the treaty. The consequence of such disregard is not negligible. Indeed, consulting our domestic law on this matter has a result that the service agreement entered into by Reficar and the joint venture is not and cannot be an investment agreement. Second, while Article 1052A refers in English to administrative adjudicatory proceedings and in the Spanish text to procedimiento contencioso administrativo, both of which are equally authentic, claimants propose to deny the meaning of this term in Spanish and under Colombian law, the only sphere where it could be applied. The position advanced by claimants is nonsensical. In particular, although claimants admit that the term administrative adjudicatory proceedings is not a defined term in the U.S. legislation, they argue that it is English language and the legislation which must be consulted, and the U.S. legislation which must be consulted to provide meaning to the term, simply because the treaty was drafted only in English. Do we really need to remind our colleagues that the Colombia-USA TPA is authentic in both English and Spanish? Be that as it may, this certainly warrants a decision by the tribunal reminding claimants about the proper application of the general rule of interpretation, this time including the relevance of Article 33 of the Vienna Convention on the Law of Treaties. With this, I conclude. Ms. Frutos Peterson from Curtis will continue with our closing arguments.
Thank you, Ana Maria. Mr. President, members of the tribunal, I don't think that I'm going to make use of the full hours we have been allocated for closing arguments. So that is a good news, I think, for everybody to make it for lunch at a regular time. Yesterday, claimant's opening statement was mostly devoted to address the standards of interpretation of Colombia's supposed breaches of the treaty. They barely spent time dealing with jurisdictional questions, and they did not address respondents' main preliminary objection based on Article 1024 of the treaty, which is that their claim is not right because at the time they filed their notice of arbitration, there was no measure capable of constituting a treaty breach and no loss or damage arising out of that breach. Claimants deliberately adopted this strategy because they want to create the impression that there might be a violation of a treaty standard in this case. They are desperately trying to push this case into the merits. But the reality is that claimants prematurely initiated this arbitration as an attempt to prevent CGR from finding them fiscal liable. That is why they rushed and submitted this claim, even though there was no measure capable of constituting a treaty breach and no loss resulting from that breach. That was their strategy decision. Claimants also revealed yesterday that if they are able to overcome respondents' preliminary objections, they will supplement and amend their claim. The indictment order was merely the pretext to initiate this case. But unfortunately, for claimants, they overlooked the requirements set forth in the treaty to initiate a valid claim to arbitration and to engage Colombia's consent under the treaty. I would like to make one last preliminary comment concerning Colombia's Article 1024 objection. Respondent has already explained in detail why claimants' factual allegations are not capable of constituting a prima facie breach of any of the substantive obligations of the treaty. We're not going to address those points again in this closing presentation, but we would like to refer the tribunal to our submissions and to yesterday's opening statement. Claimant wants this tribunal to believe that respondent had the intention on converting this preliminary phase into a mini trial without the possibility of submitting evidence. That is completely false. Respondent's position is that taking the factual allegations made by the claimants in the notice of arbitration as true, as well as the uncontroverted facts, there could not have been a prima facie breach of any of the treaty obligations. Such legal determination is not a complex exercise, as claimants argue. Claimants also suggested yesterday that they did not have to show even prima facie that there were other remedies available in Colombia, and that they're pleading that those remedies were futile or manifestly ineffective was sufficient at this stage. But as the tribunal said in the Corona versus Dominican Republic, when deciding an objection under a provisional identical to Article 1025 of the treaty, and I quote, based on the claimant's allegations and the evidence submitted by the parties in this arbitration, it has not been shown that taking a further step in the domestic legal system of the Dominican Republic will have been futile or manifestly ineffective. The same is true here, where claimants have not shown why those available remedies will be futile or manifestly ineffective. Taking the word for it is not enough, even at this preliminary stage. In these concluding remarks, we're only going to address some important issues that are worth highlighting given what we have heard yesterday. First, let's talk about the evidentiary standard. Yesterday, once again, claimants conflate the standard applicable to an objection under Article 1024 of the treaty and the standard applicable to jurisdictional objections raised by Colombia as a preliminary question. Claimants want that a presumption of truthfulness be applied to all of their allegations. But let's be clear about the relevant standards. With respect to the standard applicable to an objection under Article 1024, it only applies to factual allegations made by claimants in the notice of arbitration. It does not apply to legal allegations or even to mixed questions of law or facts, as claimants call them. The parties are in agreement as to the relevant facts that occurred until the notice of arbitration was filed. You can see that by comparing slide 38 of claimant's opening presentation and slide 7 of respondent's opening presentation. Thus, it is up for the tribunal to decide whether, taking into account those facts, claimant's claim is a claim for which an award in their favor may be made. Claimants argued yesterday that when Colombia proposed to treat jurisdictional objections as a preliminary question, together with its objections under Article 1024, it meant that Colombia somehow agreed to treat those objections under the same standard. That is not true. Yesterday, claimants pointed to a different paragraph of Respondent's October 9, 2020 letter. Dealing with jurisdictional objections as a preliminary question simply means that those objections are heard and decided before going into the merits of the case. That's what preliminary means. The text of Article 1024 states very clear that those jurisdictional objections could be decided by the tribunal together with a preliminary objection under Article 1024. The jurisdictional objections raised by Colombia are not intertwined with the merits. They are very specific objections that deal with the jurisdiction, ratione materia, ratione persona, and ratione voluntatis of this tribunal. They are mostly legal in nature and involve simple questions of fact. That is the reason why Colombia, in furtherance of the procedural efficiency, proposed to deal with those jurisdictional objections in this preliminary phase, together with the objections under Article 1024 of the treaty. The tribunal concurred with Colombia's position and exercising its powers exercises powers under Article 1024 of the treaty, and it decided to hear those objections in this preliminary phase. Claimants make it seem as if Colombia tricked them. Apparently, they were not aware that the standard applicable to Colombia's jurisdictional objection was different from the standard applicable to Article 1024's objection. That is frankly nonsensical. Claimants are sophisticated players represented by very experienced counsel, which know full well that what it means to deal with jurisdictional objections in a preliminary matter, in a preliminary phase. As the tribunal in Capes versus Guatemala held, which is also consistent with the opinions of the United States in its non-disputing party submission, the fact that jurisdictional objections are decided as a preliminary question together with an objection under Article 1024 does not mean that a presumption of truthfulness applied to the facts related to those jurisdictional objections. There is nothing in the text of the treaty to suggest such a proposition. What claimants are really trying to do is to overcome the lack of evidence in support of the facts of which the jurisdiction of this tribunal is based by arguing that their factual allegations benefit from a presumption of truthfulness and that they don't have to prove anything at this stage. That is wrong as a matter of law. claimants have the burden of proving all the facts on which the jurisdiction of this tribunal is based, and this was the time to do it. The preliminary phase lasted almost 2 years and consisted of 2 rounds of full briefing, where each party submitted multiple exhibits and legal authorities, and of course, a 2-day hearing. Claimants had plenty of opportunity to submit all of the evidence they wanted to prove the jurisdiction of this tribunal and to defeat the jurisdictional objections raised by respondent. Even claimants considered yesterday that they have the burden of proving the facts upon which the jurisdiction of this tribunal is based. It was claimants who decided not to submit additional evidence to prove their case on jurisdiction. But that was their own strategy. There would not be a miscarriage of justice here. These claimants are not particularly shy when it comes to submitting evidence. It should be recalled that they submitted 4 witness statements together with their application of provisional measures. Nothing prevented claimants from submitting witness statements or any other evidence they wish to defeat the jurisdictional objections raised by respondent. In particular, claimants complained that there was no document production phase during this preliminary stage. Well, the jurisdictional objections raised by Colombia involve mostly legal questions and involve simple facts, and that all the relevant documents related to those objections have been submitted by the parties into the record of this case. It is not clear why a document production phase will be necessary to deal with those objections. In any event, Procedural Order Number 1 allowed claimants to request documents if exceptional circumstances existed, but claimants never made any such request. Now it is too late for claimants to complain. They had almost 2 years to prove the jurisdiction of this tribunal, and they failed to do so. One minor comment on the non-disputing party submission of the United States. Yesterday, claimants remarked that the U.S. submissions is an amicus submission, and that is entitled to weight that is logic and reasoning and authority cited carries. Claimants are wrong. First, Article 1028 of the treaty defines a non-disputing party as a party, meaning Colombia and the United States, that is not a party to an investment dispute. Moreover, Article 1022 and 1023 of the treaty clearly distinguish non-disputing party submissions on the one side and amicus curiae submissions from a person or entity that is not a disputing party on the other side. The same distinction is found in Article 1022 and 1023 of CAFTA and DR CAFTA, among other treaties. As much as claimants would like to undermine the importance of the U.S. submission, the statements of both parties constitute a subsequent agreement on the interpretation of the treaty under the terms of Article 3138 of the Vienna Convention. Now, let's move to discuss the issue of ripeness within the context of Article 1016.1 of the treaty. Claimants face a catch-22 with respect to the measure alleged to constitute a breach of the substantive obligations of the treaty. If the measure is the fiscal liability proceeding as a whole and the ruling with fiscal liability, then they have clearly violated the waiver in Article 1018.2 by initiating 2 acciones de tutela, filing an appeal against the ruling, and initiating a conciliation proceeding with respect to that ruling. If the measure is the indictment order, they have 2 issues. The first issue is one of ripeness. The indictment order is an administrative act of mere procedural character that did not define any legal situation, and for that reason, there is no recourse against it. In Spanish, we say un acto de mero trámite. The second issue is that if the measure is the indictment order, then the waiver they included in the notice of arbitrations concerns the indictment order only. That means that they cannot discuss in this arbitration any supposed breaches or damages arising out of the fiscal liability proceedings or the ruling, because they have not submitted a waiver with respect to those measures. Claimants know that they have a problem because both options are fatal to their case. That is why they have gone back and forth between the indictment order and the ruling. They ultimately pick their poison in the comments to the U.S. submission, where they say, and I quote, Colombia, through the CGR, improperly brought a fiscal liability proceedings against claimants and subsequent charges on June 5, 2018. Yesterday, they committed to that strategy, saying that the measure is the indictment order and that they never said that the measure was the ruling. Mr. Seals even said that when he pointed out to the CGR decision as the challenge measure, he was responding to a question asked by the tribunal at the interim measures hearing, not to a question on what measure claimants were challenging in this arbitration. We disagree completely. Let's review the transcript of the hearing on provisional measures. Mr. Vici asked, to be absolutely clear, what do you say is the measure alleged to constitute a breach referred to in Article 1016? Mr. Seals responded, the CGR decision. There's no doubt. But I don't want to get caught up in back and forth. Let's just take the indictment order, which was when they decided to submit their notice of arbitration. Yesterday, Mr. Vici said, it is right to say that that on the basis of the request, the claimants have not already put forward, as of December 2019, matters which are now in front of us and which then we might probably be in a position to debate. What had actually crystallized at that time? He asked. The answer, members of the tribunal, is nothing. Nothing had crystallized at that moment. By December 2019, there was no measure capable of constituting a prima facie breach of the treaty and no prima facie damage resulting from that breach. Those are the two requirements in Article 1016(1) to submit a valid claim to arbitration. Is the indictment order a measure capable of constituting a prima facie breach of the treaty? No, it's not. As we have said, it is an act of mere procedural character that does not define any legal situation, so it cannot possibly breach Colombia's international obligations under the treaty. Did the indictment order cause a prima facie loss or damage to claimants? No. Let's look at the damages claims by claimants in the notice of arbitration. They claim two types of supposed damages: a harm to claimants' reputation and credit, and the legal fees and costs they have incurred in the fiscal liability proceedings. None of these types of damages, prima facie, arise out of or result from the indictment order. By their own submission, claimants were never charged with corruption or fraud in Colombia. So what harm to reputation are we talking about here? Any harm to the reputation comes from the investigations against Foster Wheeler in the United States, in the UK, and other jurisdictions. Those investigations have been widely reported in global media. Those investigations are actually criminal in nature, as opposed to the fiscal liability proceedings, which is not criminal. As to the fees, there is no causal link with Colombia's supposed breaches, as explained by the tribunal in Chevron. Yesterday, we heard Mr. Seals dismiss Chevron, saying that respondent had misread that case. But as the tribunal can see clearly on this slide, Chevron is directly on point. In the notice of arbitration, claimants requested an offsetting award in the amount of an eventual ruling with fiscal liability. After Colombia unveiled the absurdity of that request because it would grant them a windfall of $900 million, claimants reformulated the request. Now they seem to be asking the tribunal a sort of declaratory award that triggers if and when they actually suffer a loss. Yesterday, Mr. Seal said, an award could be entered and a stay subject to the stay being vacated only if Colombia, as it apparently intends to do, finds and seizes assets and sells them or converts financial assets to its own use. Besides proving our point that any damages are purely speculative and hypothetical, the tribunal cannot grant this relief. Under Article 1026, the tribunal can only grant monetary damages and restitution. Claimants' offsetting award theory is based on the Glencore award, where the tribunal granted such relief. We heard them mention this case again yesterday. Claimants wants to convince you that you can do the same here, but we submit to you that you cannot. There is a crucial factual difference. Glencore paid the ruling with fiscal liability, and thus they had a loss that the Glencore tribunal could be offset. That the Glencore tribunal could be offset. Claimants had made no such payment either voluntarily or forcefully. They haven't paid a single penny in satisfaction of this ruling. I'm going to briefly give the floor to my colleague, Elisa Botero, who will address Respondents' Ratione Materia objection. Because we will be discussing specific provisions of the services contract and claimants ask that those provisions be kept confidential, we ask the tribunal to adopt the necessary precautions right now. To be clear, the services contract is public because the fiscal liability file, including the contract, and that is why it became public, but we want to be courteous to our colleagues. So if we need to treat this in a confidential setting, we are ready to do that. Thank you.
Thank you. Just give us 1 minute.
Let's wait until we lift the ban.
We can proceed.
Thank you. Finally, we have a few comments regarding the waiver. Claimants have not real defense to respondents' waiver objection. They know full well that they violated the formal and material waiver of the treaty. As to the formal waiver, claimants argue that they comply in their notice of arbitration with Article 1018(2)(b) of the treaty because they used the same language, but only added a sentence, and I quote, for avoidance of doubt, end of quote. Well, that sentence that they added precisely leaves the waiver devoid of any practical effect. They want to be able to defend themselves in the fiscal liability proceedings and any related proceedings, which in effect means to initiate and continue local proceedings with respect to the same measure, the fiscal liability proceeding, which is being discussed here. With respect to the material waiver, Claimants insist that defending themselves is not a violation of the waiver. But nowhere in the treaty is there an exception for defensive actions. The only exception to the waiver requirement is provided for in Article 10.18.3 of the treaty, which is restrictively limited to injunction relief. And claimants are not alleging anymore that the local proceedings are covered by that exception. Claimants' interpretation defeats the purpose of the U-turn structure of the treaty, non-U-turn, I'm sorry, the purpose of the non-U-turn structure of the treaty. Professor Cohen asked an important question to claimants yesterday about the difference between the rights that they are defended in local proceedings.
Sorry, Dr. Fruitus, just to be clear, in the English transcript, it's showing U-turn. You mean unitary, do you?
Well, I refer to the terminology to the term known as no U-turn exception under the treaty. Structure.
Structure, okay. I understand.
Yeah, no U-turn structure, yeah. Is that okay, Mr. Bichi?
Yes.
Thank you. I will start again, if you don't mind. Yesterday, Professor Cohen asked an important question to claimants about the difference between the rights that are defended in local proceedings and the rights invoked in this arbitration. Claimants answered that the sources of those rights were different, since their local proceedings were based on alleged violations of Colombian law, whereas in this arbitration is based on alleged violations of the treaty. But that distinction we submit to you is totally irrelevant. For purposes of Article 10.18.2 of the treaty, what matters is whether claimants initiated or continued any proceedings with respect to any measures alleged to constitute a breach of the treaty. And the actions that claimants initiated and continued before the local courts are, without no doubt, proceedings with respect to the same measure, regardless of the fact whether they are based on Colombian law. The recent conciliation request is yet another violation of the waiver. Claimants want to explain away their conciliation request, and yesterday even suggested that it should be equated to an informal settlement lunch meeting. From a cursory review of the conciliation request, it is evident that it triggers a formal conciliation procedure, which is an essential prerequisite to requirement to subsequently file an annulment action. The language of Article 10.18.2b is plain. Any dispute settlement procedure with respect to the same measure violates the waiver. A conciliation procedure is undoubtedly a dispute settlement procedure under the ordinary meaning of this term. Claimants' artificial distinctions between a dispute settlement procedure and a dispute settlement mechanism, or between procedures with adjudicatory powers and procedures without adjudicatory powers, are nowhere found in the treaty. In short, claimants' interpretations and artificial distinctions only serve to underscore that claimants formally and materially violated the waiver. To conclude, we believe that you have all the necessary evidence in front of you to resolve respondents' preliminary objections. We are providing you with this chart that you can see in this slide. This chart summarizes our preliminary objections and contains the questions that we believe they could guide you when deciding our objections. Colombia respectively requests that the tribunal uphold respondents' preliminary objections and dismiss this case in its entirety, ordering claimants to pay all costs and expenses of this arbitration, including respondents' attorneys' fees, together with interest thereon. We thank the tribunal for your attention. This concludes respondents' closing remarks. Thank you.
Mrs. Peterson, still have time left. You want to add something else, or that you're done?
No, I am done. Thank you
Okay.
so much. And thank you for your patience this morning.
Thank you. So we now have a 15-minute break, as we had scheduled, and we'll be back a 11:45. Okay. I hope you have had the opportunity to relax a bit. Relaxation, as Mr. Seal said yesterday, we are always prepared for relaxation. So let's resume the session. Now the floor is with claimants.
Thank you, Mr. President. Mr. President, we're going to spend our time today addressing some of the questions that were raised yesterday in more detail, and attempting in the brief time we had available to address some of the new matters that were just raised. And I'd like to start with the question of risk that was so much a focus of yesterday's presentation, so much a focus of Colombia's presentation this morning. What the record shows is that PCIB, which was the local branch of Process Consultants, one of the two members of the joint venture, was a local office registered with the Colombian authorities, a taxpayer in Colombia, and the fact that there was a tax gross up is irrelevant. What's significant is that PCIB was a local taxpayer, which is, of course, one of the indicia of local presence, which in turn rolls up into an element of investment. There were over 700 personnel at that office in Colombia doing the onshore work, engineering work, supervisory work, administrative work, in order to perform these services over a period of many years on this literally a mega project for which billions of dollars were spent. Claimants did invest significant amounts of time, capital, personnel, and labor in Colombia in order to perform under this contract and to assist in building out the refinery. It took place from November 2009 until December 2018, a time span of over 9 years during which this was being performed. And of course, duration is another of the indicia of investment. And as we will describe in just a moment, there was in fact operational risk. There was in fact investment risk. And there was not a guaranteed profit, no matter how many times it is asserted. It is simply not true. But I'd like to back up for a moment. Next slide, please. To the heavy reliance on Cellini in Colombia's presentation. The treaty here does not make risk a condition precedent to having an investment. It's expressly listed in the treaty as one of a number of factors, and it's listed disjunctively. If the drafters of the treaty had intended to make risk the sine qua non of investment, it would have been very easy to do so. But instead, they chose, as drafters, to take what I suppose could be called a holistic approach. That is to look at multiple factors and weigh them in the context, of course, of a full evidentiary presentation by both sides to determine where along the spectrum from a simple sales contract, a contract to sell 100 widgets in Colombia, as opposed to what everyone would agree would be an investment, building a widget factory in Colombia in order to sell widgets to the Colombian market. Now, Cellini does say that the assumption of risk is one of the essential elements of what constitutes an investment under the convention. Now, Cellini is itself, to the extent Cellini says that that's a necessary element, although the literal language quoted by the respondents doesn't actually say that, that would definitely be a minority view. The double keyhole approach, I think it was called the double-barreled approach in yesterday's presentation by Colombia, is itself a controversial and minority view because the ICSID convention does not define investment. And the drafters of the convention, again, could have defined investment, just as they could have defined juridical person, and chose not to. And so the argument being advanced here by Colombia is that there is a separate, more restrictive meaning of investment under the ICSID convention, so that if my clients had elected to bring this as an UNCITRAL case rather than an ICSID case, this would not apply at all, presumably, in their view. Only then the language of the treaty would govern. And that, assuming that there's a double keyhole, Cellini, which is itself controversial, supplies the test, and that Cellini stands for the proposition that risk is a necessary component of an investment. That's a lot of hurdles to jump over. We think that it's the language of the treaty that brings us here that controls, with its list of factors, of which risk is definitely an element, but not the only element and not the critical element. And looking at the language of the treaty quoted in the green balloon on the right, talks about the characteristics of an investment, including, which is of course expansive, such characteristics as the commitment of capital or other resources, which we've shown here took place, the expectation of gain or profit, which we've shown and we will address in more detail because so much has been made of that by Colombia, or the assumption of risk. The language couldn't be clearer. So yesterday we heard, and the precise language from the transcript is up on the screen, that this is a jurisdictional question that can be decided just by looking at the contract. Well, that's not true under the language of the treaty. And we heard yesterday and we heard today that this was in effect a guaranteed contract, that it could not fail and that all costs would be covered plus a profit. As yesterday's transcript shows, Colombia's position was they, referring to my clients, got every penny they charged, they got it back, and we move on. But that is not the case. The contract to which Colombia's counsel directed our attention is directly to the contrary. And I'll ask Mr. Conrad to address that in detail at this point.
Thank you, Mr. Sills. Thank you, Mr. Sills. And I wanted just to alert the tribunal, but the next few slides are going to be confidential, just as Colombia afforded that courtesy to us earlier this morning in their presentation.
Would you then hold on for a sec, please, until we put the protection in place?
You can proceed.
Thank you. And so, members of the tribunal, to summarize very briefly, investment risk can come in different forms. It can be from uncertain demand for a product. It can be from uncertain pricing for a product. And so to the extent risk is a requirement of an investment, although, as I say, it's not under the treaty, and it's not under the majority of cases that we cited. But to the extent there is a double keyhole, to the extent that Cellini supplies the rule there, to the extent that Cellini actually requires as a condition that there be risk, that was satisfied here. It wasn't that. It was never that. It was never intended to be that. Could we have slide 9, please? So yesterday, Colombia argued that simple contracts for sale, or simple contracts for the provision of services, are not investments. And the general proposition is true. The contract to sell 10 widgets in Colombia is not an investment in Colombia. We don't dispute that. But because of the requirement of the treaty to look at various factors, you have to look at the particular cases that are being cited, which are radically different and easily distinguishable from the case that's before the tribunal here. Very briefly, they relied on Romac versus Uzbekistan, a supply agreement to deliver up to 50,000 tons of wheat for a 5-month period in 1996, for which there was no payment. That's a simple short-term contract to supply here wheat instead of widgets. We would agree that's not an investment, but that has nothing to do with this case involving 700 employees and a permanent establishment over a working period of 9 years. The same is true for the Nova Scotia versus Bolivia case cited by Colombia. Again, a simple contract to deliver goods over a short period of time in exchange for money. That is not an investment, again, because it's a simple sale of goods. The Sejong High case, I'm sure I've mispronounced the name there, the purchase of a single residential property to be used as a personal dwelling. Again, a single transaction not made with the expectation of gain or profit. In a house, if I buy a house in a country with which the United States has an investment treaty and something goes wrong with the house, the government changes the zoning, or my local taxes go up, or it turns out it can't be connected to the municipal water system, that's unfortunate, but it's not an investment because, as in this case, the house was purchased to live in, not as an investment. In Postova versus Greece, that was an investment in sovereign securities, sovereign debt instruments. And those are subject to special exceptions, including under this treaty. And there's a lot of dispute over that, but again, an investment in sovereign bonds is ordinarily not thought of that way. I couldn't even try to pronounce it. The Mauritius case, again, a single transaction with multiple bank transfers in a single property. And Charles Eyre, there was no payment for land. They didn't contribute to the project. So each one of these is readily distinguishable. You have to look at the actual facts, and the facts here are that this was a contract with investment risk, permanent establishment, payment of local taxes, the creation of a local branch, 700 employees over a long period of time, and has all the indicia of an investment. Slide 12, please. Now, there's been a lot of discussion yesterday and today about the ripeness of the claim. Whether or not this was an appealable issue, or whether or not there was judicial administrative recourse under Colombian law is frankly irrelevant here. What's important for international law purposes is that the adoption of the charging instrument following the submission of the free versions, which in turn followed the opening resolution, was an act that caused damage. And it caused damage by damaging the business reputation of my clients, as we plead and as we will show at the merits phase. And there's, of course, no requirement at a preliminary stage to plead and prove quantum. Now, if anything, the fact that there was no recourse within the CGR is further proof that this was an act, a measure capable of causing damage. The campaign of publicity waged by Colombia, publicizing this, defaming my clients publicly, which in the natural and probable consequence, of course, was to cause governmental agencies and other potential customers around the world to refuse to do business with them, is well pleaded and is, as Mr. Beachy said yesterday, crystallized. And it's worth remembering that this is not the first time the CGR has engaged in that kind of conduct. In the Glencore case, the CGR, which was ultimately held to account for imposing an irrational fiscal liability on Glencore, waged a campaign in the press publicizing in sensational and defamatory terms the issuance of the charges. And so here, and I know we spent a great deal of time on this yesterday, the CGR simply ignored the overwhelming evidence, including evidence generated for Ecopetrol itself, that the claimants could not be fiscal managers. At the same time, they accepted lesser proof that the members of the board of directors of Ecopetrol were not fiscal managers, again, referring to the chart we examined yesterday. Excuse me. They were let out. The only plausible explanation of that is that they were let out because they were Colombian citizens and my clients were held in because they were nationals of the United States. And the CGR never articulated a basis for liability, causation, or damages. Rather, the charges were an endlessly shifting target as soon as my client addressed one of them, the ground would change. And if one compares the opening resolution to the charging document, it's a completely different case. And the result of that was that my clients were forced to expend attorney's fees in defending that case, unlike the Chevron case to which Colombia keeps pointing. This was the direct and natural consequence of the bringing of these unjustified and groundless charges. Next slide, please. So it is the fact that an administrative act can constitute a breach of fair and equitable treatment. And it's worth recalling the quotation from Professor McLaughlin that's up on the screen now. The investor may pursue a claim for breach of the treaty standards that is based directly on allegations of administrative misconduct, irrespective of whether he has sought redress before the local courts. Although we were told yesterday and told again today that there was no redress, no possible avenue of redress before the local courts, the suggestion was made that my client should simply wait for the outcome of the CGR proceeding. We were told they should have been optimists, so that we all know how that turned out, and then seek relief. in the Colombian courts. And perhaps at that time the claim would be ripe, although I'm sure we would hear at that point that there had been an election to proceed before the Colombian courts, cutting off any right of redress. But the pleading here states that recourse to the Colombian courts, to the extent it would be required, although there is no exhaustion requirement, would be futile, and that's supported by the witness statement at the interim measures hearing of Mr. Torrente, to which no rebuttal has been offered. Similarly, we cite on slide 14 the Teco case, which similarly concludes that an administrative act can give rise to liability under the FET standard. And I think it's also worth recalling that exhaustion requirements, to the extent they exist in investment law, apply only to denial of justice claims and not to other headings of FET. Similarly, we cite from Glencore on slide 15, the same argument made by Colombia, made here, rejected in that case. The fact, and we cite also from that tribunal's discussion of Prodeco. I've already addressed the question of futility, which is on slide 16. We have pleaded compliance with that we have pursued all available and practical local remedies to no avail. That is all that is required at this stage. Colombia has presented nothing to the contrary, although, as I say, the record here does actually support that. It's worth recalling that Mr. Torrente was formerly the chief legal officer of the CGR. Now, with regard to damages, we heard yesterday and we heard again today that because of references in the press put up by Colombia to other proceedings against other companies within Foster Wheeler affiliates, not these companies, in other countries, that must be the cause of the reputational harm to Colombia. That is not the case. The reputational harm to my clients. Whether or not it is the unjustified acts, the campaign of publicity, the outrage to due process that's at stake here that caused damage to my clients, or whether, as Colombia now suggests, it was other publicity about other cases in other countries, about other companies that are affiliates of Foster Wheeler, is a classic question of fact. And it cannot be resolved on papers, and it cannot be resolved because a lawyer for Colombia asserts that must be the reason that reputational harm was suffered by my clients. It's a matter for evidentiary proof in an evidentiary hearing, which has not been held, and which this is not. Next slide 18, please. And so, as I say, the damages were incurred before the RFA was filed. The damages were reputational harm. The damages were attorney's fees. Whether attorney's fees are allowable under Colombian law is irrelevant, because this claim arises under international law. And as we pointed out yesterday, in a pending proceeding under this treaty, Colombia admitted that a tribunal may award moral damages. That is to say, damages for reputational harm. And again, that is a question for evidentiary proof in an evidentiary hearing. Can we have slide 19, please? When we first saw in recent filings that Colombia was actually asserting as the basis for its waiver claim that the claimants here were required to stop defending themselves before the CGR. We thought we must have misunderstood that, because the suggestion that we were required to drop hands against a legal assault at the hands of Colombia seemed so extraordinary that it couldn't have possibly been what Colombia meant to say. But yesterday's hearing and today's hearing confirmed that that is exactly the position they take, that a violation of the waiver is implicated by simply defending oneself in the face of a legal attack by the state. There is, not surprisingly, no authority cited for that proposition because none exists. There is not an award that suggests it. There is not any scholarly writing that suggests it. And so far as I know, this is the only time that a respondent in an investment case has actually suggested that. Perhaps a hypothetical grounded in this case itself would clarify that. The charging document as originally drafted, the opening resolution charged not only the damages that are at issue in the current CGR proceeding, but an equally large claim, or approximately equally large claim, for lost profits. And the CGR bifurcated its proceeding, went forward on the case before us, and deferred for another day the lost profits claim. But it all arises out of the same course of conduct, the same contract, and the same allegations of fiscal mismanagement. So one would think that after an investment claim is brought, if Colombia decided at that point to pursue its lost profits claim, a respondent in that proceeding would be left with the choice between, in effect, defaulting in that case and admitting billions of dollars in damages, or withdrawing its ICSID claim. And that cannot possibly be right. And in fact, the rule Colombia suggests would make it an easy tactical decision for state respondents to simply bring retaliatory actions and then argue that there had been a violation of the waiver clause by simply mounting a defense. Now, as it happens, Colombia eventually decided not to pursue that lost profits claim, perhaps chastened by their experience. But the fact is, it would have, on Colombia's untenable theory, triggered a violation of waiver, and that theory would invite retaliatory actions by state respondents. The argument made that to defend is to continue simply makes no sense. It could be charitably called a hyper-technical argument, but it isn't supported by the language of the treaty. It is the waiver is intended to prevent double dipping, to prevent taking two chances, pick your cliche, I suppose, 2 bites at the apple. This is not that. A party is always entitled to defend itself without risking its rights under the treaty. There was some further discussion this morning about the fork in the road. The language of the treaty is here in the box on the right. The only argument that's been made for a violation of the fork in the road treaty, provision, in Colombia's papers, that was made yesterday, that was made today, has to do with the fact that the treaty and my client's rights under the treaty was mentioned in the first tutela. No relief was sought under the treaty. My clients reserved their rights under the treaty. The fact that something is mentioned does not mean that a claim was submitted, that the same alleged breach has been submitted to an administrative tribunal or court. And then looking at paragraph 4B, if a claimant elects to submit a claim of the type described in subparagraph A to an administrative tribunal, to submit a claim, no claim was submitted. And their sole argument on the fork in the road claim is based on the notion that merely mentioning the fact and not seeking any relief under it, in effect informing the court that there is another source of rights as to which rights are reserved, does not trigger a fork in the road. There was much talk about Annex 10G and the use of the word alleged. Again, this is at best a hyper-technical argument entirely at odds with the treaty and its language, because what 10G says, for greater certainty in 10G paragraph 2, if an investor of the United States elects to submit a claim of the type described in paragraph 1, that is to say a claim under the treaty, to a court or administrative tribunal of a party other than the United States, that election shall be definite. There was no such election. And in fact, if we could have slide 22 up, please. In fact, the tutela court lacked jurisdiction to hear claims arising under the treaty. As we say here, the Colombian Constitutional Court has actually held that investment treaties do not involve fundamental constitutional rights. Fundamental constitutional rights are the subject matter with which the tutela courts are charged. Not only was this not alleged in the pleadings before the tutela court, it could not have been alleged because it was outside the jurisdiction of that court as a matter of Colombian law. Next slide, please. So I don't want to rehearse at length the history of how we got here, but Colombia sought to raise preliminary objections out of time, and the tribunal will recall that there were extensive discussions, and it was decided that Colombia could raise those questions and could also raise on a preliminary basis its jurisdictional objections, reserving its right to make those objections at a later stage of the case on a full evidentiary record. And if Colombia's present submission that this is it, this is the trial, were correct, that couldn't possibly have been left in the procedural order. But the tribunal knows what it ordered, and it knows why we're here today. This is not a full evidentiary hearing. It's not on a schedule that would accompany a full evidentiary hearing. The notion that, well, we should have simply shown up with our witnesses, or I suppose that Colombia could have shown up with its witnesses, is simply, is groundless. And for Colombia to now assert that this is it, on a, I have to say, groundless claim that we've been at this for 2 years, it's actually been 7 months since their first memorial was filed. But the length of time is not what's critical. This is a preliminary hearing on preliminary questions. On on slide 23, we cite from the RSM decision. Under 1020.4, Colombia is required to prove that the claim as alleged is certain to fail, accepting all facts as true. But if it isn't under 1024, then Colombia is raising its claims under ICSID Rule 41.5. And ICSID Rule 41.5 sets essentially the same standard here. And here is RSM's analysis about Article 41.5's manifestly without legal merit standard. It must go to jurisdiction or the merits. It must raise a legal impediment, not a factual one. And as we showed yesterday in multiple slides, Colombia has raised or sought to raise a host of factual issues that cannot be resolved on papers and cannot be resolved at this time. And it must be established clearly and obviously with relative ease and dispatch. Next slide, please. So, looking at the quotes from, again, the RSM award and from the PAC-RIM award, both again before distinguished panels, discussing both, in the case of PAC-RIM, Article 10.20.4 under CAFTA, and in the case of RSM, Article 41.5, the standards are essentially the same. And Colombia is represented by extremely sophisticated counsel with a leading practice in this field. And they certainly know what Rule 41.5 provides. And what it doesn't provide is for some sort of accelerated written final hearing on the merits, although that's what they're trying to turn this into at the last moment. It would be, if that were to be the case, if this was, as they said, it, and this were the final hearing, I have to say that would be a clear violation of due process. There was no notice that this would be that hearing because it isn't. Under Procedural Order 41, these are all to be, under Procedural Order number 1, these are all to be considered as preliminary questions. As preliminary questions, they all fail. They all fail legally, and they all fail factually. I can understand why Colombia would wish to short circuit the process at this point, because my clients have been the victims of an outrage to due process before the CGR. An outrage to due process in connection with the issuance of the indictment, as they put it. Although Colombia now seems to suggest there's no right to amend or supplement, that can be, there is clearly such a right. It could be done by amending or supplementing. It could be done by bringing a new case and consolidating. If it is amended, there will be a new waiver, as there always is when amendments are sought. But those are procedural matters for the next phase of the case. There is no basis to dismiss this case at this time, and it should be allowed to proceed forward to a hearing on the merits with all appropriate procedural protections. Thank you, Mr. Chairman.
Thank you, Mr. Schultz, for your presentation. Before we close this hearing, adjourn it, we have, and I draw your attention to items J and K of procedural order number 2, which deals with post-hearing briefs and statement of costs. You'll have it. Yeah, what is said here is that the parties are willing to consider the submission of post-hearing briefs to answer specific questions from the tribunal that the tribunal may want the parties to address in writing. At the conclusion of the hearing, the tribunal will confer with the parties on whether such post-hearing briefs will be filed. The exact length, format, and due date of post-hearing briefs, if any, shall be discussed by the tribunal and the parties at the conclusion of the hearing. I would like to hear what you have to say about those post-hearing briefs. I do not want to influence your decision. I'll be unable to do that, I'm sure. But just to let you know that you keep in mind what we have in the record, the memorials, the exchange of letters, the transcript of this hearing, and your initial presentation yesterday and this closing presentation today. Mr. Schill, do you think we need additional information in the format of post-hearing briefs?
If you bear with me 1 second.
Yeah, if you turn on the mic, yes.
Could you bear with me 1 second, Mr. Chairman,
Yeah.
while
Okay.
I confer with my colleagues? Mr. President, I think as your comment suggests, there is an extensive record here. The issues have been vetted. Of course, if there's a particular question that the tribunal feels has not been sufficiently aired, we'd be pleased to respond to it in writing. But I have to say, from claimant's perspective, we think that these preliminary questions, and they are only preliminary questions, are ripe for decision at this point. And if the tribunal is of that view, we would certainly not insist on yet another round of written submissions, perhaps to be followed by a further argument. Much though we enjoy meeting with the tribunal and with our colleagues across the table, I think the record is sufficiently developed on these questions at this point for the tribunal to decide.
Thank you very much. Dr. Peterson.
Thank you, Mr. President. Colombia believes that you have a complete record in front of you, that all the submissions from the parties, you have received them. And as you said, we had our hearing here today. So we don't think that there is a need for post-hearing briefs on the questions that you have in front of you to resolve. Thank you.
Thank you very much. I'd like to make a comment here because we at several instances since yesterday, we mentioned ripe and ripeness. The only thing I can tell you is that this case is ripe for decision. So irrespective of the decision, but the case is ripe for decision, which justifies the extensive use of the two words. But that's it. The other topic is item K, the statement of costs. The parties shall submit statements on costs at least 21 days after receiving the final transcripts of the hearing or submitting post-hearing briefs, whichever is later. The exact length, format, and due date shall be discussed, blah, blah, blah. Marisa, may I ask you a question? when will we get the final transcript?
Thank you, Mr. President. The parties will have 30 days to submit corrections to the transcript. So, taking that into account, we will send you the videos and the audio of the hearing early next week. And then you will have 30 days to submit corrections in then. And then, according to the PO, will be 21 days after the corrections are submitted and the transcripts are finalized.
Okay, let me ask you a question, you both. For me, I'm going to winter time shortly, so we'll be working July, August. It's winter for us, January, February for you. Based on what Marisa has just said, I think we could have a due date for submission of final transcript by the beginning of July 1st or 2nd. I don't know, normally when we say a date, it's a Saturday or Sunday. Let me check here.
July 1st is a Friday.
Okay, so July 1st. Is that okay for you?
Well, that's actually, I mean, it would be okay if ordered by the tribunal, but that is the beginning of a holiday weekend in the U.S. What I would...
Oh, it's the 4th of July. Yeah.
Mr. President...
Right. Mr. President, Bob, I'm sorry to interrupt. Maybe we can settle on the last week of June?
What I would suggest instead, I'm sure we'll be able to reach agreement on this, after we discuss with our respective teams what their personal and professional calendars look like, perhaps we could simply come up with an agreed schedule to present to the tribunal. I'm sure we'll be able to reach agreement on that.
We can do that, certainly, promising that you will have them before the 1st of July, probably.
Yeah, in terms of statement of costs, you're very well acquainted on the way we have the costs indicated. We don't need that you send us all bills and everything. If something happens, if the counterparty has any question, then we can ask the tribunal to determine to order the submission of the supporting documents. Okay?
I'm confident there too, Mr. President. We've all been down that road, and we know what the form in this sort of work is. And I'm confident, and I would hope that we won't have to bring any such matters to the tribunal, because I'm sure we can work out the format as well. We've both done this before.
Yeah, we know the law firm, so we are convinced that we can have your extensive experience in arbitration of the two CHIMs make me extremely comfortable, and my colleagues as well. Okay?
Thank you for the confidence.
Okay. Do you have, before we close, any specific matter that we'd like to discuss, or we are done?
Nothing for the claimants, Mr. President, other than to thank the tribunal for its time and attention, and to wish those who aren't from Washington, the tribunal, our colleagues across the room, safe travels home, and very pleasant summer for those of us who live on,
winter for me,
and a very pleasant winter to those who live in the Southern Hemisphere.
Okay. Ms. Peterson.
For the Colombia, we just want to thank the tribunal, and our colleagues, for giving us the opportunity to present our case here before you. We don't have anything else to add, except that's just my colleague to thank everybody involved, and all the junior associates that probably are not here in both teams, that they have done a wonderful job to support us, and of course the Secretariat and the other services behind the scenes. Thank you.
Thank you very much. Before we adjourn, I'd like to thank you, both sides, for their hard work. The professional approach taken throughout the time until now. And I'm sure I'm confident that this will continue. I have no reasons not to trust. But it was very, very important, especially because we are coming back after a long period of Zoom hearings. We are here in person. We have some friends and colleagues behind the screen following us by Zoom. But the fact that we are back, it's very important. And I sincerely hope we can continue holding in-person hearings from now on. I certainly hope that COVID is controlled, ceases to be a pandemic and become endemic, and that we can live, see friends, hugs, kisses, and so on and whatnot. We missed everything during those 2 years. And a special thanks to the representatives of the United States of America that submitted their written interpretation of the treaty and for their presence during this hearing. I thank you very, very much. I look forward to seeing you very soon again. Okay? Thank you.
Thank you, Mr. President.